This is Professor Blakey, and the topic for today's video is, what is the journalist's shield? So when you think about the journalist's shield, you always want to put yourself in the position of the journalist. So what if one of your sources asks you to go off the record, which is kind of sexy and fun to think about, but what does it really mean to say go off the record? Does it mean they want to keep the source name anonymous, or do they want to not let you publish the information that they're telling you? So you kind of have to figure out what it is that is going to be off the record or confidential, and then what sort of laws would protect the journalist and the source. So there are laws of privilege that come from the First Amendment or from court law, state laws, and there are also state laws that are statutes or constitutions that actually set out the rules of what a shield is. So the shield will prevent you from testifying about the source's name or about the content of what the source told you, including films and videos and papers that you got. So the shield law is a little bit to do with privilege, a little bit to do with the First Amendment, a little bit to do with statutes. And you have to ask yourself a series of questions about it. So let's get started. Are you seeking knowledge? Well, then you've come to the right place. GLEN MAVEN Digital Publishing. The topic for today's video is, what is the journalist shield law? The journalist shield law refers to a lot of different things. Sometimes it's called the reporter's privilege. Sometimes it's called the newsman's privilege if you still lived in the 1940s and you're only talking about men. Sometimes it's called privilege, and it's a little confusing. So you got to ask yourself a series of questions. The first question is, and in the context of US law, what kind of law are we talking about? Are we talking about the Constitution and the Bill of Rights, in which case it's the First Amendment? Are we talking about federal laws? There is no federal statute providing a shield law. Or are we talking about state laws? And every state is different. Some states have a shield law or a privilege, and some don't. Most of them do. The shield law is in, most often, a statute or a code. In California, it's made into part of the Constitution of the state of California. And then some states, and this varies along with the shield law, some states have state law in terms of court opinions, which is called common law, giving a privilege to journalists not to reveal the name of their source or what documents or information or photos the source gave them. So we're talking about privileges, which is more of a privilege from the Constitution or a privilege not to give evidence, and then shield laws, which is similar, but has to do with state laws, statutes that provide a shield that prevent the journalists from having to answer a subpoena telling them that they have to come to court and give the name of their source or the content of what the source gave them. So shield laws are usually state constitutions or statutes, and privileges are either the federal US Constitution, the First Amendment, as part of the Bill of Rights, or a privilege can be in a state court opinion, which is called common law. So we got privileges. You don't have to testify because you have a privilege. A shield, you don't have to testify because you have a shield. If this ever came up, you would want to assert both a privilege and a shield at state and federal level. And because of the variation there, you really need to look beyond what kind of law it is and more into what kind of case it is. So if it's a grand jury case, There is United States Supreme Court law that says in the case of a grand jury, which is a particular type of proceeding, the journalist cannot assert a privilege or a shield and has to reveal the information. That's by law. Of course, as an individual, you could not follow that law, and sometimes journalists do not. A grand jury is a particular type of proceeding. It's not a trial, but it's more of an investigation where they're trying to determine if there's enough evidence to go forward with a case. And they want to have the rule that everyone has to give the information so the grand jury can decide if there's enough information to charge someone with a crime. So in a grand jury, this is a major exception to privileges and shields, journalists by law have to give their evidence. But again, that's by law, and through acts of civil disobedience or personal moral convictions, you can keep your sources confidential. You might have to leave the country. A civil case and a criminal case are different. There's just a completely different set of values and issues and principles that have to be balanced. In a criminal case, if the prosecutor is asking a journalist to do the prosecutor's job in a sense, and to deliver information that helps the prosecutor get a conviction in a criminal case, it's pretty likely that the journalist would be able to assert a privilege or a shield and not have to testify regarding their confidential source name or information. If it's a criminal case where the criminal defendant needs the information that's in the possession of the media regarding the guilt or innocence of the person, then we're balancing the right of a person to have a fair trial and to get access to the information that would prove their innocence versus the freedom of the press. And we're talking about the freedom of someone to walk around in the world. Then the rights of the criminally accused to obtain that information would probably overcome the shield, and the journalist would be ordered to give the information. When it's a case of a criminally accused person and they need that information that the media has in order to prove that they're innocent or not guilty. In a civil case, if the media is not a party and there's just two people arguing in a civil case and they want the media to provide information, most likely the privilege or shield will be upheld. Certainly in California and New York, the shield or privilege would be upheld, and the media doesn't have to give evidence of their confidential sources or information to people that are in random lawsuits, civil lawsuits. If the media gets sued and the media is a defendant, the journalist has to ask themselves whether they're going to give up their source and quote unquote burn their source and give up the information in order to win the civil case. For example, a defamation case, somebody claims that the media defamed them, hurt their reputation. The person needs to, the media side needs to defend themselves and say how they researched and sourced the information. They might have to burn their source to prove that they didn't recklessly disregard the truth. But most likely it's a case of where it's two people that have nothing to do with the media and they're just seeking the media to provide additional information, in which case the shield or the privilege will apply. That's a brief summary of the confidential sources rules around privileges and shields. The takeaway message is that in most states, there is a shield law that prevents journalists from having to testify in court about their confidential sources. But always keep in mind that you don't want to promise confidentiality too quickly, because you could be ordered to reveal your sources. If you don't reveal your source and you're under a court order, you could be held in contempt and have to go to jail indefinitely until you do reveal your source. And secondly, there's also the issue of if you do reveal your source, if you do reveal your source, you could be sued by your source for essentially breach of contract, even though you don't have a formal contract. It's called promissory estoppel. Promissory estoppel is a contract-like theory that says that the source can sue the journalist for damages. So you don't want to be sued by your source. You don't want to violate a subpoena from the government or from another party. So it's a tricky area. So when a source asks you to go off the record, really consider the risks and benefits of agreeing to that. So you don't want to agree to it unless you're really getting good information. And if you are, then agree to the confidentiality and stick by that confidentiality agreement, because that is your word as a journalist.